Welcome back, viewers, to the PI show. We're talking about medical negligence, and Tony in particular.
Well, viewers, just before the break, we talked about a number of cases of medical negligence or alleged medical negligence. What we're going to do now is take you to the law, or what the law is in relation to medical negligence. The key case here is a matter of Rogers and Whittaker, which is a 1992 High Court decision. Alice, do you want to take us to the facts of the case?
Yes, I will. Tony, this is a case regarding a lady who had an eye injury. She had one good eye and essentially one bad eye. She was totally blind in one eye from an accident she'd had as a child. And over the years, she had coped with having only one eye. She was a housewife, she had a family. And then one day, it was suggested to her that she could have some cosmetic surgery to improve the appearance of her bad eye. And it must be stressed at this point, Tony, that the surgery was cosmetic only. It was just to make the eye look a little bit better. There was absolutely no medical benefit in terms of treatment whatsoever. And this lady went to see the ophthalmologist, the surgeon who was going to do her operation, and according to the evidence in the case, she was very anxious about losing the sight in her good eye, and she pestered the guy for hours with lots of little questions about what would happen, what the risks of the operation were, and whether or not she would risk losing the sight in her good eye as a result.
Can I stop you there for a minute? John, what was the risk of her losing the sight in her good eye?
1 in 14,000.
Isn't that too small?
Tony, as I'm sure you can see, it seems such an insignificant risk. It is a tiny, tiny risk. Two things about this case. First is that, unfortunately, that exact thing occurred. The lady got what's called a condition called sympathetic ophthalmia, which is where the condition spread to the other eye, and she actually ended up blind in both eyes. And the doctor thought the risk was so small he never mentioned it to her. But she was able to demonstrate through her evidence to the court that she was so nervous about losing the sight in her good eye that she should have been told, and that she would not have had the operation had she known.
Well, that raises an interesting question, Alice. One of the things that would have been asked of her at the trial is, if you're aware of the risk being 1 in 14,000, would you still have gone ahead with the surgery? And the obvious thing in hindsight is what, John?
Most likely she would have.
Well, she said she wouldn't have.
Really?
Yeah, she said she wouldn't have.
At all?
I doubt very much. Look, I don't want to criticise poor Mrs. Whittaker, but at the end of the day, I think that if someone gave me a 1 in 14,000 chance of something going wrong, albeit as significant as this, I probably still would have taken my chances. Do you think she was lucky winning this case, Alice?
I think, Tony, that this is a very unique case for those sort of reasons, and you're quite right. The majority of people would say 1 in 14,000, that's a tiny risk, that's not going to affect someone like me. Mrs. Whittaker was able to show in her evidence that she was so anxious that she genuinely wouldn't have gone ahead with the operation.
And given the fact that she only had one good eye...
That's right.
She wouldn't have done anything to jeopardise that.
That's right.
The key to this case, from what I can read, is that Mrs. Whittaker said many, many times, what are the risks? Is there a chance I'll lose my sight? And that's what a High Court found for her.
That's right.
There's issues of informed consent here.
There are issues of informed consent, and there's an issue of failure to warn too, of a risk that was significant to the particular patient. Obviously, it's a bit of a controversial case because it's subjective. It relied on that particular patient, and you could say, well, any patient can come in and say, well, this is important to me.
Ellis, this is the perennial case, isn't it?
That's right. It's a seminal case.
The damages were pretty high, weren't they, Tony?
Oh, very high.
She was awarded, I think, $800,000.
And that's back in 1992.
That's right.
That's, what's that equivalent to today? 2 million?
It's a lot of money. A lot of money. But the important thing is they had to go away from the established law, which was the Boland Principle.
That's right.
What is a Boland Principle, John?
Alice?
Or do you want Alice to...
The Boland Principle, Tony, is a principle which is established by a case by the name of Boland, and interestingly is actually embedded in our legislation now. But essentially, if you are alleging medical negligence against a particular practitioner, you need to get other practitioners in Australia of that same field to comment upon it and say that they would not have conducted the surgery or the offending procedure that way, or that they would have warned a patient. Other doctors in the same field essentially need to find fault with the offending doctor, and as you can appreciate, it's very hard to achieve.
But in this particular case, what he did is what other doctors in his field would have done.
That's right.
So they've actually strayed away from the Boland Principle.
They have, and this was such a landmark case because they did stray away from that Boland Principle, and the High Court said, well, we know we've got this case where he's done what other doctors would have done, but this patient's proved that this was a serious issue for her, and the court found for her.
Now, the High Court back then, it was a 6 judges that gave this decision.
Right.
Is a very, what's the word, a left-leaning panel of judges?
It could probably say that the High Court certainly had a lot of sympathy with the plaintiff, and it could be said that the High Court certainly had not a lot of regard for the Bolam case. But as you can see, the legislature and the government wrote it into the legislation.
This is a
at the end of the
classic
day.
case of judge-made law.
That's correct. That's
Viewers,
exactly right.
the key to this case is the fact that this lady was rendered blind. She had no sight at all after this, and of significance, the High Court said that a practitioner's got a duty to warn of all material risks of proposed treatment. And a risk is material if, in the circumstances of a case, a reasonable person in the patient's position, if warned of the risk, would be likely to attach significance to it. 14,000 to 1, I still would have gone ahead with the treatment.
Look, Tony, you're not wrong, and many people would say exactly the same thing. This lady was able to prove that it was a serious issue for her.
But Tony, would you have done it if you only had one good eye?
Yes, at 14,000 to 1, I still would have gone ahead.
Yeah, I probably would have too.
Can I just look, we're going to have to touch briefly on this other case.
Yes.
It's a case of a lady who had, she went in pregnant and German measles.
That's right.
And we're not going to have much time because time flies.
It
Alice.
does when you're having
And
fun.
so can you give us the facts as briefly as you can?
I can. Briefly, this lady was about, I think, 14 or 19 weeks along with her pregnancy. She had one child already, and that child contracted chickenpox. The lady started to feel unwell, and she presented to the hospital, where she requested an immunisation against the chickenpox because she knew that she was pregnant. The hospital elected not to give her that immunisation, and unfortunately her baby was born with some severe disabilities as a result of the lady catching the chickenpox and having it while she was
And
pregnant.
John, she lost. And why did she lose? Do you know what?
Causation, Tony.
Yeah. This is an extraordinary case, this, viewers.
I couldn't
because-
believe it when I was reading it. But
Well, the court found, obviously, there's a duty of care. They said there was a breach of that duty. They said it was foreseeable that if they didn't carry out... Or foreseeable in the sense that the lady wanted the treatment administered to her
That's right.
because of the risks
That's right.
associated without getting the treatment. And in the end, they had to go through a study, Alice.
Yes, that's
however-
right. They went through some expert evidence. The court even found the hospital was negligent, but unfortunately they couldn't fine for her because they couldn't prove enough that the immunisation would have actually helped her. It wasn't
So-
effective enough.
She fell over on causation.
That's right.
They say that the damage to the baby wasn't materially caused by the inaction of the
failure
hospital.
to
it
immunise.
could have been possible, but not probable.
Not
That's
probable.
correct.
That's exactly right.
Viewers, this is a very interesting subject and we've got many, many cases to discuss and we will do it in the future. So I do want to thank Alice for coming on board. You've been fantastic.
Thank you so
as
much,
usual.
Tony.
And viewers, please stay tuned. We're going to a sponsors break and we'll be back with the mailbag shortly. Thank you.